Good evening and welcome back to Trial. Oh, good evening and welcome back to Trial Watch with Demetra. I am Demetra Lit all day, or as I like to consider myself in my legal capacity, Judge D Lit. Now, it is a self proclaimed title. Of course, I'm not a real judge, but hey, if you don't tell anybody, I won't either. Good evening, the cynical one. Good evening, Winter. Shout out to Winter from my Liga Beaver. I need, or anywho, shout out to you for the heads up. But we are back tonight on both channels because this is a news report, news story that I brought up. Lit off channel. We had an open live and discussion. So of course we want to bring you guys the newest update. Okay. Good evening, Foot. Good evening, Daniel. Good evening, Tracy Whitehead. If you have not seen, or if you don't, well, towards the end of this live, if you're catching this on the replay, you will be able to click in the top right hand corner and catch that first initial live. We had a great discussion, a great chat today. I'll make sure to link that to this video. You should be able to see it if you're watching the replay pop up. Good evening, Tracy. Good evening, everyone. I don't really do weekends, but I didn't come in this morning. You guys, I'm not gonna even lie. I got caught up last night. I was up until I was even an ungodly hour. I was up all night, all morning watching. Guess what? Reacher. I was binge watching season 1, season 2. It got right to the end of Reacher on Prime, Amazon Prime. Yeah. Okay. So, but I hope everybody had a great day, and I hope y'all have a great and awesome weekend planned ahead. I have some ripping and running to do tomorrow. But other than that, in order to get ready for the Houston Livestock Show and Rodeo, go get my outfit and all that jazz. I'll be going to the rodeo next week. My members, you guys will be getting exclusive footages of all of that. So tonight, this is the case of they are calling this the Michigan House of Horrors. Okay, that's what Court TV and several news outlets and what have you have dubbed this case. It's regarding the Pontiac, Michigan woman who Kelli Bryant is her name. Hey, Lamar Copeland. Oh, for real? Lamar says, hi, Demetri. I live right. Did I say I'm watching? I live right near where this happened. I'm here in Detroit. What a shame. It is a shame. Hey, happy birthday, watching from Cloud9. Happy birthday to you. Happy birthday to you. Happy birthday, watching from Cloud9. Happy birthdays to you. May the good Lord bless you. You're 51 years young. May the good bless you. And you keep going strong. Happy birthday! I need a round of applause. Hold on. Do I have a round of applause? No. We got to work on that, right? Happy birthday to you watching. I hope you have a fantastic new year ahead of you, right? It's a blessing. I see your new avatar. Now, this Now, this story is a tragic story indeed out of Pontiac, Michigan. The mother's name is Kelli Bryant. She is 34 years old. She has a total of 4 children. One of the children is not involved in this particular case because that child lives with the father. I don't know whether it's a boy or girl. Okay. But her name again is Kelli Bryant. This happened in Pontiac, Michigan. It came to light last month. Okay. She's 34 years old, mother of 4. in 2020 to pretty much fend for themselves. She left 3 of her kids, 2 girls, 1 boy, in this home alone. Literally alone. Not for the night, not to go spend the night somewhere, not because she had to go run somewhere real quick, take care of a family emergency. No, she left those kids in the house since 2020. And as of today, with the updates, they're still saying that she had not seen her kids. She was sending them food and the scant groceries that she did by way of DoorDash, Instacart. She wasn't even going in the home. She has been charged with 3 counts of first-degree felony child abuse. With those 3 counts of first-degree felony child abuse, she could be facing life in prison. Now, not only did she neglect her children and leave them there, abandonment, look at the squalor of that home. Hi, Renee. Okay, Renee. This is an actual factual picture of the inside of that home. This, it makes me think of what things on the, wait a minute. How do they say that saying? Things on the outside. How did you say that? The inside is not always what the outside give. Things on the inside are not always what they appear. The reason why I'm misquoting that quote is this is the outside of where she left from the home, the townhouse. From the outside, from the street view, from the DoorDash's perspective, from the neighbor's perspective. This is what they saw driving by. This is what they saw if you said, oh, okay, let me go check, and see where she lives. But the inside told a whole different story. And the whole house was like this. Now, when we first heard of this story, I'm going to go ahead and give y'all a reminder in case anyone's not familiar. Let's play a really quick reminder, one of the first news updates. And then what's going to happen during this live is that we're going to actually look at the bond hearing. You may recall, if you're familiar with this case, that's growing, that's coming along. It's a brand new case. When she first was arrested, her bond was set at $250 million. Okay, $250 million was her original bond upon her being arrested. So tonight we're going to do a live reaction and review of the hearing, whereas her attorney, of course, was trying to see about getting that lowered. But of course, let's first look at a news deal to kind of bring us up to speed, remind everybody, get everybody on the same page. Again, shout out to Winter for letting me know to check that there had been some movement in this matter. I do, of course, appreciate you. Of course. Oh, that's the background, child. Okay, now this was one of the initial updates from 2 weeks ago. This just got to going 2 weeks ago.
Yeah, literally. I mean, I found out about this on my way into work this afternoon, and there are no words. I mean, this is absolutely horrific. This is by far, I think, one of the worst stories we've ever covered.
Why is it on mute? Oh, no, it's not on mute. My earphone's on mute.
Here at Fox
My bad.
2.
Let me start it over.
Yeah, literally. I mean, I found out about this on my way into work this afternoon, and there are no words.
Please hit the like.
This is absolutely horrific. This is by far, I think, one of the worst stories we've ever covered here at Fox 2. And I want to warn everybody out there that the details are very disturbing.
If you think about the horrific ads you see on TV to spur donations for animals that have been abused or are living in terrible conditions, multiply that by 10.
A horrible story of abuse and abandonment. Investigators say 3 kids were living in a condo on Lydia Lane in Pontiac for years, alone in horrific conditions.
There was garbage, trash piled 3 and 4 feet high, covered with feces all through the house. It doesn't look like the toilet or the bathtub had been usable or workable for quite some time, primarily because of the feces and trash. I don't think they had basic hygiene knowledge of what to do. They hadn't been given hygiene products for years, and toothbrushes, etc.
A 15-year-old boy and 2 girls ages 12 and 13 in the house of horrors since at least 2021, according to the Oakland County Sheriff's Office. Their mother or someone else would leave prepared food on the porch once a week.
They had basically been locked in the house without any kind of guidance or basic hygiene or any kind of education for years.
The kids were discovered Friday. The landlord called police and asked them to do a welfare check because he had not heard from the mother since December.
We went to the house to check on what was going on there, and had no idea that there were kids there, let alone kids in grave situation.
Their 34-year-old mother arrested and being held at the Oakland County Jail. The children taken to an area hospital and are now in the care of a family member.
We showed up at the house. Michigan. The young boy did have communication with the mom and said the police were there, and she said hide. When we took the kids out of the house, they had difficulty walking because their toenails were so long. They hadn't had any grooming. Incredibly disheveled and unkempt, hair very matted, filthy.
Authorities trying to figure out how this abuse went on for so long without anyone knowing about it.
It's pretty heartbreaking that the kids would have to live under those conditions. People just kind of get in their car and go. Another of my neighbors, we were just talking today, and she said to me, she said, look at all this snow. I don't see anybody out helping each other, shovel each other's snow. So I think people are just kind of just doing their own thing now and just kind of going in their places and closing the doors.
It's still just so incredibly hard to believe that these kids were in this condo for so many years, never seeing the sunlight, never trying to leave. They were apparently spending their time watching TV and playing games, not in school. We know that they had been enrolled in Pontiac schools years ago, but what happened? Why did they fall through the cracks? And it just, I mean, it's mind-boggling. The girls that we talked about, ages 12 and 13, the sheriff says they were sleeping on pizza boxes, old pizza boxes.
That's ridiculous.
A lot more to come on this.
That's ridiculous. That's absolutely ridiculous. Okay. Winter says, Demetria, the landlord may be in trouble now too, because the townhomes or condos was not registered as a rental unit, which is mandatory in Michigan. And see, that's probably why the house was able to get to that squalor too. Because remember, that's one of the first things we talked about when we actually watched the news conference, the press conference. So we watched the press conference when it first came out, and it wasn't until they changing it up now, but they said it wasn't until the landlord called for a wellness check because he hadn't gotten rent in a couple of months. But she's been gone since 2020. They was leaving food on the porch like it was for dogs. Now, if she's been gone since 2020, that means the son was all of maybe just turning 10. The girls was 7 and 6? And abandoned in that way, and your mama right there in the same city? It's crazy. So anywho, let's check out. I'm hoping from this, and it's a live reaction with you guys. They had a hearing, and a hearing was to see her attorney trying to get her bond reduced from that $250 million. Okay. And that was an extremely high bond, maybe just done for the dramatics of it all. But the judge at that time said the bond was set that high so the mother wouldn't have an opportunity to talk to the kids and coerce them or get them to not speak. Now, that's what the judge was saying at that time. And the fact that she did she was a flight risk. She had been gone and from pillar to post for all these years. Okay, I'm trying to switch the so let's see if she's successful in getting her bond reduced. And I'm hoping that we'll find out a little bit more information from her talking about what was going on. Okay, so this is a live reaction of the recent hearing, the newest update. Thank y'all for joining me again. Hit the like.
Calling People versus
If
Kelli
you like.
Bryant, case number 250216FY.
Good afternoon, Your Honor. Kanika Ferenczi on behalf of the people.
And good afternoon, Your Honor. Cecilia Caranago here on behalf and with Kelli Bryant. She is present from the Oakland County Jail on Zoom, and we have no
And there she
objections
go.
to Zoom, Your Honor.
Thank you, Ms. Bryant. Would you state your name for the record, please?
Kelli Bryant.
Thank you. This is the time and date set that the court scheduled for defendant's motion to modify the bond and for a reasonable bond. Ms. Carandongo, you did submit a supplemental pleading. And just to clarify, it references a letter to the court. There was only one letter that you submitted, correct?
Your Honor, this morning, so I obtained a letter from a community support that was sent in a separate email
That's
to the
her
court,
lawyer.
not into the court file. And then there was also a letter in regards to the medical condition
I have
that
both
my
of
client
those.
has that was set
I
separate. So
have
there
both
should
of
be one
those.
handwritten. Okay, perfect. All right. Yep. Okay.
Ms.
Yep. There was
Ferenczi,
just the one.
Ms. Ferenczi, you received those as well?
Yes, Your Honor, I received all those documents this morning.
All right.
All right, that's
At
the
this
state
point,
prosecutor
the court
down there in the blue
is
background.
prepared to review the items that I had mentioned on the prior date, which were those things that I will address or attempt to address, the factors to determine which pretrial release option is appropriate and under what terms and conditions. I had indicated on the prior date, I'm looking at the defendant's, if any, prior criminal record, any record of appearance or non-appearance, any history of substance abuse, mental condition, the seriousness of the offense charged, the employment history, any financial history as it relates to ability to post bail, the availability of a responsible member or members of the community who would vouch for and monitor the defendant, any facts showing community ties, family relationships, also the length of residence, and any other factors bearing on the risk of appearance or danger to the public. Ms. Carandongo, anything you wanted to add that the court did not already have at arraignment?
Well, at arraignment, I think the
Right on the queue. Thanks for
pretrial
joining.
services verified Ms. Bryant's information, but quite frankly, I mean, many of the things that were put in the motion and the supplement were that was added information. I think the court was somewhat concerned about being able to verify the information. I attempted to do that. I just, in the supplement I submitted to the court, I listed all of those factors that the court just mentioned on the record, and listed, I guess what's favorable to my client and what's not, and also how that information was verified. So if the court would like me to, I can go through, those factors, again, as I had mentioned before, both at arraignment and I think also in the first written motion and then in my supplement. I think for Ms. Bryant, we all know the court can't deny bond, so I think everybody's agreeing with that. And then it comes down to whether, essentially a cash bond is appropriate at all, or if it should be a recognizance bond with some type of conditions. And I know the people, will argue that it should be a cash bond. My position is that the only time that the court could do a cash bond is if the court finds either that she's a flight risk or that she poses a danger to the community at large. If the court would like me to, I can go through all the factors that I mentioned and information.
Let me interrupt you, Ms. Carandongo, because
now I'm gonna try to stay quiet, okay? But she is a flight risk. She already took flight from her children for 5 years.
one of the main things that was of concern at arraignment was the lack of a stable address for Ms. Bryant. That was one of the things that was the focus of the arraigning judge.
That's correct, Your Honor. And Ms. Bryant has a stable residence. She had a stable residence before that, her arrest as well. Now, of course, there's additional concerns because of the publicity that this particular case has received. So Ms. Bryant would not, and I did provide also, I think prior to the last court hearing, the court with the address, and I indicated also who resides at that address for the court. I'm very concerned about putting any of that on the record, given, the kind of posture of this case, but that is with a family member who has also lifelong ties to the community. So Ms. Bryant does have a stable residence to go to. I have also spoken, to other family members, and I spoke to the person who provided a letter to the court, who is also a pillar of the community. Every one of them are willing to, to supervise and I shouldn't say, vouch, but make sure that Ms. Bryant gets to court. And I think, a tether could also assure all of that. The court would be aware 24/7 where Ms. Bryant is. So she was not transient. I know the previous judge made some statements that Ms. Bryant was transient. She was absolutely not transient. She was staying at a residence and had stayed there for quite some time. That is not a residence given the circumstances as they are right now that she would be returning to, and that is mainly due to the amount of publicity that this case has received. So of course now there's new concerns, but she absolutely does have a residence to return to, and I don't believe she was ever transient, Your Honor.
Okay, so this is my live reaction. So it is what it is. That's even freaking worse for them to be saying, and for them to keep saying about how she does have a stable residence. She does have a permanent. Yeah, the problem was her address on the same place where she left them children suffering and hungry and filthy while she was living in a stable, good residence. Girl, boo. Do you hear yourself, lady?
All right.
And I don't think there was any evidence of that either, quite frankly.
All right.
It would have sounded better if she was homeless.
Ms. Ferenczi, is there any comment?
Yes, Your Honor, I would like to address residency, and then because I only received the supplemental motion this morning, I would like to respond to much of what was documented in that motion, Your Honor.
Okay.
But in regards to residence, what the people find troubling is that the individual that the defendant is being asked to be released to and reside with isn't the one that wrote the letter. That individual is not vouching for her, and I don't believe that individual has appeared in court and is willing to provide that voucher to the court. That is a concern, and it actually speaks to the high level of instability for Ms. Bryant. A lot of the statements about her transient nature is in conflict with what she told police when she was interviewed. So I do find it troubling when the information is, at times it feels like it's self-serving for Ms. Bryant. I'm happy to address the other issues though, Your Honor, in the supplemental motion.
Your Honor, may I address that particular point that Ms. Ferenczi is making? So I will just tell the court, as an officer of the court, I've spoken to many of Ms. Bryant's family members. And here's the reality of things. The children, I think everybody has now known where the children are. And so the children are with family. And so it becomes a very difficult balance as far as, supporting, sending letters. I had conversations with the individual whose address, was offered as a residence, and that individual wanted to talk to Ms. Bryant too. There are issues with setting up, phone accounts for the Oakland County Jail and actually establishing that communication, to be frank with the court. I spoke to that individual about a letter when she spoke to me, and again, this is, as an officer of the court, when she spoke to me, she was absolutely willing to provide that letter, but there was also just a very short amount of time in which to accomplish that, and she had requested to speak with Ms. Bryant first on the phone. And it's my understanding that there was no previous, account set up for that, and there was 2 days to do it. So that's the reality of it. So it has nothing to do with the person not being willing to vouch for her. That person indicated to me that she absolutely would supervise Ms. Bryant and make sure, that she comes to court. But again, and I think that's the concern for the court, is that the court would like someone to say they're going to make sure she comes. And that brings me to some other things I put in my motion, which I don't think the people are disputing, that this young lady,
Let me stop you for a moment, because on the issue of where she will be staying, the court needs to be convinced that this is a stable residence if there are any modifications to the bond where there's a potential that she could be released. I understand the nature of people being hesitant to come forward given the amount of publicity, but the court has to be convinced that Ms. Bryant would return to court and also that she will not be a danger. So go ahead, Ms. Kirindano.
Yes, so in regards to the return to court, Your Honor, which goes to the flight risk portion of, the bond factors that the court can consider, Ms. Bryant has no criminal history. So there's no history of her, appearing or not appearing in court at all, which means she has no history of failing to appear. She, and this information was verified by pretrial services. In addition to that, Ms. Bryant, and this is in the police report, so I don't think this is something that will be disputed by the people. Ms. Bryant, when she was contacted, so she was contacted by the Sheriff's Department and the officer in charge of this case in regards to this case once the children had been located, and she paid for a Lyft ride to the Oakland County Sheriff's Office to turn herself in to talk to the officers. I've been in practice for a number of years now, and I don't think I've ever had a client who actually paid for a share ride to go turn themselves into the Oakland County Jail. And
so it might be simpler. It might be simpler if I go through the issues that I don't believe are in dispute.
Okay, and before the judge do her thing, let me just also say that her court-appointed attorney up there, Cecilia, she's also trying to have a gag order put into place, right? And she wants very limited to no press releases on this. So she's going to try her best, and I hope she don't get her way and try not to get a lot of case facts out in this hearing. I hope, but they have not decided to do that. So let's see what happens. This is a live reaction. But yeah, they trying to keep stuff out the press. Hell no.
One, the fact that Ms. Bryant turned herself in after being contacted, I don't believe that is in dispute.
It's not, Your Honor.
That's correct, Your Honor. The only issue that I would argue that is in dispute, her ability to cooperate with law enforcement.
Understood. Let me finish going through the items that I'm looking at. There is not a prior criminal record.
We do not dispute that.
All right. There is no record of prior non-appearance or flight to avoid prosecution.
That's understood, yes.
Okay. So the issues that the court needs to hear about are, and the court is already aware of the seriousness of the offense charged, and that is certainly something the court will be taking into consideration in modifying any bond. But we have not heard regarding the employment status, financial history as it relates to an ability to post, ties to the community, ties to family members, and the residency is still an issue. So Ms. Kirindano, if you can address those matters.
Yes, Your Honor. So in regards to the personal circumstances, which I think addresses many of those issues, Ms. Bryant does have a mental health diagnosis. This is reflected in the police report, and I'll tell the court I did submit a subpoena for her records for CNS, which I noted in my supplement that that's where she was going. I gave the court the name of her case manager for treatment too. It's not enough time to get those records, but this was noted. I also believe it might have been noted in the pretrial services report.
It is
right now. I believe so, and that information was verified, I believe, by her father. So she wasn't receiving any medications, but she was receiving treatment. In regards to her physical health, which is one of the other considerations, I did provide the court with a letter that indicates a medical diagnosis for which she's supposed to be receiving infusions. The jail can't accommodate that. Ms. Bryant also was scheduled to have surgery, which that time has passed, but she has issues with which could be internal bleeding that was supposed to be addressed via surgery, and she hasn't been able to have that surgery. I again submitted a subpoena for those records. It's just simply not enough time for St. Joe's, but I did provide as much information as I could to the court on that. Ms. Bryant also, she is a lifelong resident of the city of Pontiac, which that was verified, I believe, by pretrial services. I also believe that the community support letter that I provided to the court indicates that that person is a resident of the city of Pontiac and has known Ms. Bryant since she was 14 years old. Also, her information in regards to being a Pontiac resident was verified by her father through pretrial services. I don't think there's a dispute that Ms. Bryant has lived in the city of Pontiac her whole life. She went to school in the city of Pontiac, and she's never left the city of Pontiac. So that indicates that she has strong ties to the community. I also believe that both the community support letter and also pretrial services, as well as information in the police report, indicate that she has family in the area. Her parents are here. I also indicated to the court that she has siblings in the city of Pontiac. She again has community support, which is not family, but longtime family friend, who appears to be an upstanding member of the local community, who provided a letter to the court indicating that she was in support of Ms. Bryant. So she absolutely has community support. Again, it's a very difficult situation. So when I say community support, I want everybody to understand that that shouldn't mean that, we should be worried about the children, because everybody has made the children a priority. So I just, want the court to know that. But Ms. Bryant absolutely does have a lot of support in the community. In regards to substance abuse, there's no history of substance abuse for Ms. Bryant that I'm aware. It was not noted in any of the reports, and she has not indicated to me that she had a history of substance abuse or substance use. Even marijuana or alcohol. So I don't think that is something that should be of concern to the court. But again, if it was, the court could order her into testing to ensure that she's not using any illegal substances. That's a pretty standard condition of bond. Ms. Bryant also submitted in regards to income. Pretrial services report did note her past history of employment. I noted in my supplement that she was also, prior to her incarceration, she was employed. She was paid through the state of Michigan. I could not obtain that information because it's confidential information, and it was something that was shared with me a few days ago. So I was not able to obtain verification, but Ms. Bryant did inform me of who the person at the state of Michigan that was responsible for her was, and she provided me with that name. Unfortunately, it's a very common name within the Department of Health and Human Services.
This sounds like so much bullshit.
I was not able to obtain specific information. She does have a pay stub. It's at the residence she was at. I made contact with the person who resides there. They were trying to locate the paperwork for me, but they were not able to locate it as of yesterday evening at night.
Pause. So everything basically that her attorney is saying, what I'm hearing, is stuff that she hearing from this girl, but she hadn't verified. She ain't got no verification on no job. She ain't got no verification on no diagnosis. She ain't got no verification of no income. All this stuff is stuff that the client telling her, but as of yet, they haven't actually been able to verify. Girl, boo.
9 p.m. But she was employed, taking home about $800 a month. So that was what she was making at the time she became incarcerated. That amount of money a month would still make her indigent, which she's already been found to be, which goes to her ability to post a monetary bond. Oakland County appointed her an attorney because she didn't have the funds to hire one. So I think, but she did have employment, which is also something that ties her to the community. I just think her employment would not be enough, to post a monetary bail. I don't believe there's any family members that have funds. Like I said, they're all caring for the children, and that's financially stressful too. Nobody has money to post bond for her. At this time, I don't believe. The employment history, what was disclosed to pretrial services, was verified. Again, it appears that her father verified that information for pretrial services. And some of the other employment that she had was also, verified through the family court case. There was discussions about that. I'm not entirely sure if Ms. Ferenczi was on there when that took place, but it is also information that's been provided to the Department of Health and Human Services. Now, the risk to the community, that's one of the factors the court must take into consideration as well. And again, the chance of her reappearing, I wanted to just address that briefly. The court could address that by placing her in a steel cuff tether that she can't remove from her leg. The court would be aware at all times where she is. If she failed to appear, the tether would indicate where she is. But again, Ms. Bryant turned herself in and actually was inquiring, and I think the people would agree as to the charges she was facing. She knew she was potentially facing serious charges. She's aware. I've met with her probably 10 times at this point. She knows what she's facing. I don't have any reason to believe she has nowhere else to go. So she's a Pontiac resident. She's been here her whole life, and I think if she wanted to flee the state or go somewhere, she'd have done that, already, I think, because she was again not apprehended.
So I'm going to allow the prosecutor to respond to what you have said so far, but I will change a couple of things or modify. You indicated that pretrial services had verified her employment. That's not what the report reflects. It reflects that the defendant reported she had been unemployed since August of 2024. No sources of, no sources of income were reported. Prior to that, she indicated where she had been working for about a month. So I realize that you are saying you have not had an opportunity to get all of that confirmation, but that you have been seeking it. Ms. Ferenczi?
Thank you, Your Honor. Your Honor, as the court has already noted, the allegations and charges in this case are very serious. Defendant, as the court is well aware, is being charged with 3 counts of child abuse, first degree, and there is a very high likelihood of conviction. The people are happy to provide any facts or evidence if the court would like to hear it, and the initial guidelines call for significant jail time. Your Honor, as I already indicated, the people do not dispute that Ms. Bryant turned herself in and that she cooperated with law enforcement. But as the court is also aware, that does not equate any sort of assurances that she will.
Welcome back, Senator Fran.
In regards to the mental health diagnoses and that she was being treated by CNS, there's no proof of a diagnosis, nor were any dates provided to confirm that this is accurate. The people at this point do not believe the defendant is a reliable source of information. She has a history of concealing and deceiving. Okay. That is what we have here, Your Honor. And without any sort of proof, I do not believe that the court can use that as accurate information. In regards to defendant's physical health, again, there was no verification of this medical condition. What was provided was a treatment plan from the clinic at Oakland County Jail. And it seems like she is receiving that treatment that is necessary at the clinic. The clinic teams is necessary. There was an additional allegation that the defendant needed transfusions and a possible procedure, again, not supported by documentation. But Your Honor, regardless of that situation, I would be hard pressed not to address the reason why we're here today. The reason we're here today is because defendant did not provide her own children, the victims here, with basic medical care, basic needs for years.
You better say that.
And this irony of her condition right now is not lost on me. And it seems like she can and is being treated appropriately at the clinic at the county jail. Your Honor, in regards to Ms. Bryant's employment history, again, no proof was provided about her employment status. And as the court has already highlighted, the information that was provided has not been confirmed even with pretrial services. So again, the people do have the concern that defendant is not a reliable source of information. What the people can confirm is that Ms. Bryant abandoned her children, or the victims in this case, in an unlivable residence where several rent payments lapsed.
All right, let's go, prosecutor. Let's go, prosecutor. Okay, how we gonna care about her having a health issue when her kids couldn't even barely walk out that house because they toenails for so long? She had 2 girls, 13 and 15, up in there. Nobody giving who giving them their feminine hygiene? Who telling them and teaching them? They would have started their periods probably in the time that the mama been gone. And she wants somebody to worry about her bleed.
In regards to defendant's ties to the community and the support alleged in the supplemental motion, upon information and belief, the statements that Ms. Bryant had made to the police are quite the opposite regarding her level of support. Again, she has a history of deceiving those who were attempting to support her for years. And it is difficult for me to imagine that all of her beliefs about her alleged support systems have completely changed within 2 weeks of her being in custody. And honestly, it does feel self-serving, Your Honor. The letter that was provided to strengthen her community support argument was not, again, as the court has already heard, was not from the individual who she is requesting to be released to and reside with. That individual in the letter wants to remain anonymous. How is that considered a voucher or a support for the defendant? In the letter, the individual does not make any statements about how they intend to assist the defendant if she were released, and when the last time they even spoke. That individual also admits that the defendant lied about the victim's whereabouts. They also stated the defendant knew that this individual was there if she needed help, but defendant never reached out. This is all very troubling to the people, and it is telling about the serious instability of defendant's support and her willingness to rely on that support. No one is willing to vouch for the defendant. Your Honor, in regards to defendant's potential flight risk, the people do believe the defendant is a potential flight risk with the level of local and national attention and her lack of community ties and stable housing. Most importantly, we believe that she does pose a danger to the community, specifically the victims who are members of the community, who she egregiously and intentionally neglected for years. And one other point the people want to address is the risk of reoffending. The people do believe the risk of reoffending is high here. Again, in her own statements to the police, while she was cooperating with law enforcement, defendant was not accepting or acknowledging what she did, which places a high risk of reoffending. And Your Honor, our request has always remained the same. We are requesting a high cash bail, no cash surety, no 10% provision, Your Honor.
All right, thank you. Ms. Kirindongo, this is your burden to modify the bond at this point. So any comments that are not repeating what you've already said, but anything else in conclusion?
She said, don't tell me the same shit.
I will try not to repeat myself, Your Honor. I just wanted to say that in regards to the bond amount or the kind of bond, quite frankly, the court would be much more assured of Ms. Bryant's appearance if the court was to do a surety bond, because it would involve potentially a bail bondsman who would also, in addition to any other supervision the court would order, would also be supervising her whereabouts. So actually asking for a cash only bond, I think on behalf of the people, for me, would be less of assurance of her, if that's what they're going to argue, of her appearing. A cash surety bond, on the other hand, would involve another party being a bail bondsman. That all being said, Your Honor, I think I provided a lot of specificities in the information that I provided to the court. Reality of it is that, you can't get this information in writing in 2 days. Nobody ever has that information when a person is being arraigned at, first arraignment date. And, again, given the level of attention this case has received, it's been difficult. the person signed their name to the letter. So the court knows who this person is. And I think everybody can appreciate, you know, given the level of attention this case has received, why people don't want to show up on screen here with all the cameras and the news. And, you know, I don't think that that's anything that would be abnormal. That being said, I think if the court was to follow the bond statute, again, Ms. Bryant's bond, I don't believe should be a cash bond. It should be a recognizance bond with conditions, which as I indicated, could include a steel cuff tether, pretrial supervision, mental health treatment, drug screens. And, you know, all of those things would assure her reappearance and would also assure that the court knows where she is. So I'm asking based on that. And I think, you know, in regards to reoffending, we know who the complaining witnesses were. I don't believe there's any risk of reoffending. The children, again, you know, would not be in Ms. Bryant's care.
All right, thank you. At this point, the court did set this for a separate hearing in order to review whether there should be a modification of the bond. And as I indicated, the party seeking the modification had the burden of going forward with this. So the real question for the court is there a substantial reason to modify the original bond as set? Now, the purpose of the bond and pretrial release conditions are to ensure the defendant's return to court and also the protection of the public and alleged victims in the case. The purpose of the bond is certainly not to punish, even though this is an extremely high impact case. There is much interest in the outcome of this case and in the bond. So, but the law is very clear that with certain exceptions, a criminal defendant is entitled as a matter of constitutional right to have a reasonable bond or bail established for pretrial release. Cash bond is permissible if the defendant's appearance or the protection of the public cannot otherwise be assured. The court recognizes that this bond review hearing was set in a fairly short period of time, and some of the information that I requested, according to defense counsel, could not be provided within this time. I'll also note that the principal charges in this case are felonies, but not strictly assaulted crimes under the court rule. So at this point, I have reviewed all of the factors that the court is to take into consideration in determining the proper bail. The court has also reviewed the pretrial services report, and in that report, there was still a question as to the residence. However, for purposes of going forward, we will use the address that is listed on the complaint and also in the pretrial services report. In terms of the mental health concerns, the court will address that as a condition.
Hey, Ms. 719, happy Friday.
I am still not satisfied that the court can at this point say that there is a guarantee of a return to court. The defendant has not been a flight risk in the past. However, the potential penalty in this case is quite high given the nature of the charge. The protection of the public and the victims is also a concern, and I do share some of the concerns that were mentioned by the arraigning judge in terms of the defendant's potential to reach out to the alleged victims, the children in the case, to try to influence any testimony, and I'm going to deal with that issue. So I realize that there may be a need to do further review of the bond, but I do find that the court has an obligation to set a reasonable bond, and the current bond amounts to a denial of bond. So what I'm going to do is modify based on the information that we have that is verified. So I'm going to modify the bond in this case. I'm still requiring a cash bond for purposes of ensuring that the defendant returns to court to give further support to protection of the public and to prevent reoffending. But I'm going to reduce the bond to a $50,000 cash bond at this point with the following conditions. The defendant will be on pretrial services supervision. There's to be no alcohol or illegal drug use, no possession of a weapon, no assaultive conduct of any sort while this case is pending.
Hey, Abby,
No
good to see you in the
contact with
chat.
any child under the age of 18. Absolutely no contact with the alleged victims in this case. That means no contact at all, including no personal contact, phone calls, text messages, no reaching out to parties who have control of those children right now, no contact with them whatsoever. I am going to impose a home confinement electronic monitoring device. The defendant may not leave home except for medical emergencies, court appearances, court-ordered testing. And if employment can be verified, it is not verified at this point, then seeking and maintaining employment. But at this point, that has not been verified. So I don't want there to be any confusion in indicating that the defendant can go to and from work. We need verification first. Any other travel will require permission of the court. No return to the address of the alleged incident. No return to the address of the alleged victim. Any changes of address would have to be provided to the court within 24 hours. Those would be the modifications to the bond at this point. Any questions as to what the court is requiring? And I will note that
but who gonna post that money for?
Be aware that if you violate any condition of release, you would be subject to arrest without a warrant and may have your bond forfeited, revoked, new conditions imposed in addition to any other penalties if you are found in contempt of court. Any questions, Ms. Kirandongo, as to what the court is requiring?
Just a clarification, so that's still no surety?
Correct.
Right.
Ms. Ferenczi, any questions?
No, Your Honor, thank you.
And if Ms. Kirandongo, as further information is received, I know you have subpoenaed some information. You can provide that to the court. The court is willing to do an individualized review later
just
as
happened.
well.
Oh my God.
And also, if I did not indicate, a mental health evaluation and following any treatment plans as a condition of bond, since mental health conditions were reported.
Oh my God.
So she would be able to leave in order to get that accomplished, I'm guessing, correct, even though it's not a medical emergency. It would need to be a separate, I think, exception to the home confinement.
That would have to be something that pretrial services will be further involved in.
Thank you, Anna.
All right. Thank you. Ms. Ferenczi, any questions?
No, Your Honor, thank you.
All right.
Yeah, I don't know if y'all just heard what that judge just did to that lawyer, but let's talk about a couple of things here. And I want to say again, welcome to the chat, avid watcher. I always see you in my comments. It's good to see you in the Lit Lane jury box this evening. And thank you everybody for who came in. So her bond has been dropped from $250 million cash only bond to a $50,000 cash only bond. Okay? So what that means is she doesn't get to pay 10%, 15%. A cash only bond means that someone needs to put up not 5,000. They got to put up, somebody has to be willing to put up $50,000 cash bond in order for her to be released on bond. A surety bond is where somebody put up their house. A surety bond is where you get the bondsman. Okay? Because the bondsman in turn put the whole amount up, or what get held at the court. So it's $50,000 cash only. So that would make me say, okay, her defense attorney want to talk about how she has some pillars of the community who's willing to vouch for her, even though who've known her whole life and all this and all that. Okay, so let's see if one of those pillars of the community is going to be willing to put up $50,000 cash only. And everybody is entitled to a fair bond or what have you, fair bond, right? Lord knows I wouldn't want to be sitting somewhere and I don't get no bond. So I get it. However, I almost, in my official capacity as Judge D. Litt, I started to hold the defendant and her attorney in contempt for standing right up in this court, for sitting up in this court and lying like they doing. Who not able to get a paycheck stub in 2 weeks? So nobody was able to call the job and get an email that had them email over the paycheck stub, right? Why those pillars didn't know the kids was in the house like that? Exactly, just like the family. And people say, well, okay, well, it's not the family fault. No, it's not the family's fault. However, it's not the family's fault or their responsibility. It's her children. But in my opinion, when the family in this situation after the fact, how can we trust that family to say they gonna do the right thing? How can we trust that family to what they saying they gonna do for and not do for? These kids ain't been seen in almost in 4 going into a 5th year, and they all in the same small city. So how come the family wasn't making sure and vouching for her and vouching for them kids for 5, it's over 4 years. We just got into 2025. But 4 years is too long. They have the new management. So you mean to tell me you see her, and okay, let's talk about this mental health. Okay, all of everything that the defense was saying as a bargaining tool to get some type of leniency for the defendant, right? Saying that she has a stable residence. Okay, and that she is not homeless. Okay, that's what you're saying as a something to help her get out. But why she wasn't with them kids in that stable residence? Why she left 3 of her children for 4.5 years in an unstable residence? How stable is that residence? Well, whoever she was living with and who wrote a letter for, whereas they let her live there for all this time and provided a stable residence and didn't ask where them children was. And then she want to say about how the mental health portion. Hey, family, and Jill, they have to know. And then talk about the father, her dad would vouch for it, and he verified her mental health condition. So you mean to tell me, so now everybody aware that she got a mental health condition, right? So you know that she had a mental health condition. You know she needed medication, needed all that type of shit. But yet you ain't seen these kids in over 4 years, and yet you seeing her, and she living somewhere. The children not living there for over 4 years, and you vouching for this mental health condition. Wouldn't that ring more of an alarm? Wouldn't that be more problematic? Oh Lord, I know my daughter got some mental. I know she bipolar and shit. I know my daughter schizophrenic and shit. I know my daughter deal with depression and shit. I ain't seen these kids in 4-some years. I see her all the time, but don't see. Oh. Y'all know I gets in my bag, right? Because it was pissing me off listening to this attorney, but the defense attorney has to do their job. And guess what? If I was a defendant, I would want an attorney who advocates for me. I would want an attorney who fights for me. Everybody is do that. But at the same time, when you bringing bullshit in, it's bullshit. And now all of a sudden she got all these health conditions and shit like that. She wasn't going to no damn school meetings. She wasn't having to take care of kids or nothing like that was stopping her from going to get her health concerns taken care of. Why wait till 2 weeks she been in jail and all of a sudden now she bleeding internally? If she bleeding internally, the jail gonna make sure she get to the hospital. She more likely to get better health care sitting her ass up in that jail than she probably been taking care of her own self outside the jail. She been in jail for 2 to 3 weeks. She already now getting her mental health taken care of. Now she on her medication. Now she got a goddamn treatment plan. It sounded to me like she didn't have none of that before she went to jail. And the jail then gave her a very stable residence. And the jailhouse gonna make sure she show up for court. Why should she be in more comfort than the children were? You know, I'm real grateful for my family, you know, that they gonna, you know, they know what's the priority, you know, and it's always supposed to be the kids, you know what I'm saying? Don't worry about the grown one, but let's worry about these children. I'm real grateful for my family for that, because this family here, I hate to be hypercritical, but when we go ahead and just talk about the facts as they are, I would prefer for the family to stand down. It'd be better to seem like to me if they just stand down and just go ahead and help them kids now. It's a reason why they don't want to show up in court for her. They embarrassed not only of her, they're ashamed of themselves, as they should be. How would I feel if this was my grandkids? I'm in the same city with my grandchildren, and this is what they've been going through. Yeah, it would be my kid fault, but it would be my fault too as the grandmother for just being that shitty. I'm absolutely amazed that the courts out there and family services out there put them children with family. Them children don't bit more know them people than they know a foster family. They ain't seen them for over 4 years. The kids now are 15, 12, and 13. Now the 15 is easy, quick math. That means that boy was something around either finna be 10 or 10. The girl 12, what's that? 7, 6? They don't know them people. They ain't seen them at Christmas, Easter, birthdays. They ain't seen them. All they been seeing is the damn DoorDash people dropping off stuff on the porch. So, you know, I feel like, you know, the court did what it was supposed to do as far as making sure they was able to, well, how I'm trying to put this, how I'm trying to phrase this. The court did a good job with modifying the bond from $250 million to $50,000 cash bond, meaning the bond now is a reasonable dollar amount. 50,000 is more reasonable for the charges because she didn't kill nobody, thankfully. Okay, she didn't assault anybody physically. So that 50,000 bond is more so it lined up with the charges. And the court did an excellent job in making sure that it stayed a 50,000 cash bond. By making it that way, that's pretty much making sure that she don't get out of jail. You know, if I don't see some kids I know exist for 4 days, I'm asking questions. Where them kids, right? 4 years. Absolutely crazy. No damn bond. That 50,000 cash bond is pretty much saying no bond. I just am amazed, you guys, that the defense attorney sat there and literally tried to sell the court a bunch of bullshit about a job and about stable residence when the judge and the prosecutor was able to come back and say none of that stuff is verified, confirmed, or true. Now, y'all, before I get out of here, this is very much so now. I'm LinkedIn. I'm going to go ahead and start deep diving into the court records. Not that, I'm going to get busy with this one here. But it's another case out of Michigan with the lady. She just got charged with unaliving her son. I believe she buried him in the yard. I'm going to follow up on that story too. I hate to, like I said initially a few weeks ago, I said, what the hell going on out there in Michigan? I mean, it's problems all over the world, all over the United States, but it has been very heavy, and very tragic stories regarding these children coming up out of Michigan. And I'm talking about not just I'm not talking about the residents. I'm more so talking about the CPS or whatever type of child welfare system they got out there. How all these kids slipping between the cracks. Yeah, I want y'all to see how this lady, I love this judge. I'm going to liken myself like this judge, Winter. I'm going to model myself like this judge here. She is so classy. She is so graceful and dignified. Okay. I'm going to model myself like her. And she has the shade. Okay. And she is elegant and shady. Okay. Remember, she told that lady, would you like to add anything else without repeating yourself? The shade, okay? Winter told me good luck with that. Girl, boo. Now check out this part, y'all. I have to play this again. Y'all, look what she did look what she did to the defense attorney.
And if Ms. Kirandongo, as further information is received, I know.
Just a clarification, so that's still no surety?
Correct. Ms. Ferentini, questions?
Oh, she said correct. I didn't hear her correct the first time. My bad. All I heard the first time was there's still no cash surety. And then I heard the judge say, Ms. Ferentini, any questions? So I thought she had totally disregarded that question and ignored her. Okay. My bad. The judge in the Harris girl case, Naziah Harris, is shady as well. I don't believe that the judge that we became familiar with for the preliminary hearing, I don't believe that's going to be the same judge for the actual criminal trial. Don't quote me on that, but I don't believe so. Just like right now, this judge that we're seeing here for this hearing is not the same judge that we saw for the arraignment. Mm-hmm. It did sound like she ignored the hell out of her. She sure do look off. Yeah, but you know what? I think she's trying to look like that purposely. She's trying to look indigent. She's trying to look like, ooh, help me. I'm just a little poor rag doll. You know how you get, well, some of y'all might not. Well, anywho. Because they got pictures floating around of how she been doing. This is how she went to jail looking. Okay? She went to jail with her sewing in. And mind you, as we just heard and learned in this hearing, she been working. She been having a stable residence. No excuse. What could be the reasoning? We got to find out. So now I want to go ahead and start digging into this deal. I'm finna go ahead and get into the court files and all that type of stuff and see if I can get more like the statements and stuff. So I'm gonna get busy, y'all. I can assure you, I got busy on another case and did some deep diving, and then the woman pled guilty and didn't even go to trial. How you like them apples? But that's neither here nor there. Unfortunately, in the world of crime and wrongdoings, it's steady going and ongoing. So we'll never be lacking of content. So she be looking like she want to get off that bench and fight. Who that judge? No, so far she won't be the actual trial judge. She stated that at the end of the hearing. Yeah, she won't be. I will, and I was absolutely already subscribed because you had told me that name before. All right, you guys. Y'all have a terrific Friday night. I woke up so late today, and then I started doing, I do have a little, believe it or not, I got a little part-time job that I had to attend to. Believe that shit or not, but I do. I keep telling y'all that. So that's why I didn't come on, but I'm glad I was able to come live on both channels. Thank y'all so much for the support. Thank you for the super chat in the clouds, the specific. I like the word of the day is specificity. Specificity. The specificity of it all. Okay. All right. Y'all go look that up. Good night. Oh, no, I'm not. Specificity of it. Like the specifics. Like, the specifics. Bye, y'all. Have a great night.
Thanks for watching. Do not forget click the subscribe button and hit the bell icon. Like, comment and share. See you next time.